And is it generally the practice of special counsels to appear in a public hearing? I know you have a couple of questions on this, but I want to reiterate this.
That is my general understanding, yes.
And can you tell us again why I understand you want to stick up for the prosecutors, the people that were part of the investigation. Can you tell us why it's important for the American people to hear directly from you about your investigation, what you discovered, the process that you went through?
Well, as I said in the beginning of, I think, in my opening remarks, there have been mischaracterizations about my work. We did our work in the best traditions of the department, and I know I keep coming back to this, but the attacks, the mischaracterizations that most offend me are not just prosecutors, but career FBI agents, support staff in the department. These are people who devoted their lives to public servants, to being public servants. They have not, they're not self-promoters. They're not people who like to go in front of the cameras and defend themselves. And I feel that they have been vilified in a way that I think is awful.
What's the effect of that on our democracy?
Well, I think it drives people away from public service.
Yeah. Is it a form of witness intimidation?
I think it's even deeper than that. I think, you know, when we get to attacking the people who are the good guys,
Yeah.
I just don't know where that goes. It's counter to how I was raised.
And let me ask you, even after this deposition today, are you still willing to appear at a public hearing before this committee and speak directly to the American people about your investigation?
Yes.
Can I jump in really quickly just on the witness intimidation issue? As I understand it, you were asked a lot of questions about filings that your office made as it relates to trying to protect witnesses, specifically the gag orders. Do you have any regrets about the steps that you took as it relates to seeking gag orders against this defendant in an effort to protect witnesses?
Our applications for orders limiting Donald Trump's ability to intimidate witnesses, intimidate court staff, intimidate my staff, I have no regrets about that.
Dovetailing on that, have you only been further convicted in the decisions that you decided to make as it relates to that in watching some of the president's actions even in present day?
I think the record of our case speaks for itself on these issues.
Could I just follow up on the gag orders relative to the defendants? In every case, a judge decided that that was warranted, correct?
In the cases in the District of Columbia, a judge
Correct.
did decide that, and the Court of Appeals agreed. They narrowed the order, as I said earlier. In Florida, we applied for an order because of statements Donald Trump had made that I viewed endangered FBI agents. That hadn't been decided when the case was dismissed.
Thank you.
And just to kind of finish up on this point, you yourself, I'm not sure if this was discussed by the majority, but have you yourself been intimidated as a result of the actions that you took in this case?
I'm not going to be intimidated.
Have you been threatened?
Yes.
Have you learned of other persons, whether they worked under you as attorneys or other support staff? Are you aware of any threats that have been made against any of them?
Yes.
And, okay, I'll stop there.
Mr. Magoo. Thank you, Mr. Smith. I really have two questions. First question, which our counsel ably covered, just so we're clear, you wanted to testify publicly today, correct?
Yes, I was willing to.
And Chairman Jordan declined that opportunity, correct?
Yes.
Any thoughts as to why Chairman Jordan is scared to have you testify in public?
I'm not going to characterize the chairman's decision. I offered, he decided that we would do it in this setting, and that is what it is.
Well, I think Americans who review this transcript, once it's concluded, will understand why. If you have any questions.
Marcus, let's come back to you.
Okay, thank you, sir.
I'm going to switch gears a little bit to your appointment as special counsel. Do you recall when you were appointed as special counsel?
Yes, it was November, I believe, November of 2022.
Does November 18th of 2022 sound right?
That sounds about right.
Do you recall the day that Donald Trump announced his candidacy for the 2024 election?
I believe it was shortly before that.
So who offered you the position of special counsel?
The Attorney General.
And what was your understanding of why the Attorney General felt it was necessary to appoint a special counsel in this circumstance?
I believe the Attorney General made a public statement about why, and that public statement is my understanding.
We can maybe enter that public statement in a little later. But what did you understand the scope of your investigation to be specifically when you were appointed?
The scope was defined by the appointment order, which encompassed the two investigations that I've referred to today.
And can you just make the record clear again, just briefly describe those two investigations and then appointment order?
Sure, and I don't have the order in front of me, so just generally.
Actually, so we'll make that an
Yeah.
exhibit. We'll make it an exhibit. Let's make the appointment order an exhibit. And this will be exhibit 11, I believe. Make it easier just to refresh your
Sure,
recollection.
thank you.
So after you've taken a minute to review it, and please take your time, the question will be, what did you understand the scope of your investigation to be?
Okay, so consistent with this order, the scope was two investigations, both of them ongoing at the time. The first was an ongoing investigation into whether any person or entity violated the law in connection with efforts to interfere with the lawful transfer of power following the 2020 presidential election or the certification of the Electoral College vote held on or about January 6, 2021, as well as any matters that arose or might directly arise from this investigation.
Do you know why, or have you heard why the Attorney General chose you to be the special counsel?
Why he chose me?
Yes.
No,
Okay. At the time of your appointment, I understand you were living in the Netherlands. Is that correct?
that's correct.
Did you lobby for this position?
No,
Did you petition the Attorney General to be the special counsel?
I did not.
Did you reach out to any former colleagues of the Department of Justice expressing your interest in being the special counsel?
I had been in contact with a former colleague by the name of Marshall Miller. He had returned to the department sometime that summer, and I had spoken to him and expressed to him an interest in, if there was the right position, returning to the department.
Ultimately, why did you accept the special counsel position?
Because I thought I was the right person for the job. I knew that this would be a challenging job. I knew it would be a job where whoever held the job, or whatever decision they made, somebody would want to attack them for that decision. And I felt that given my nearly 30 years as a prosecutor, it made me uniquely qualified to do the work.
Did you have any reservations about accepting the special counsel position?
No.
There were a lot of attacks on you shortly after you were named and throughout the time as special counsel. You said earlier, I think you used the term intimidated. I guess, how did you move forward consistently with those attacks while special counsel?
I think attacks and praise are noise, and as a prosecutor, I've learned to tune those things out. I'm more concerned, again, about the attacks on my staff. But for myself, I understand that that's can be part of the work at times.
Did you accept the role, as some have suggested, because you had animus towards President Trump?
No.
Did you accept the role, as some have suggested, because you hoped to influence the 2024 presidential election in favor of the Democratic nominee?
No.
Did you accept the role because you thought it would help the Democratic nominee by prosecuting Donald Trump before the election took place in 2024?
No.
Let's consider the same facts related to the attack on the Capitol on January 6th or the mishandling of classified documents. So that's the facts that we're going to consider here. Take the same facts but insert a president who was a Democrat. Would you have still accepted the role of special counsel?
100%.
Considering the same facts, so the same fact pattern of the attack on the Capitol on January 6th, the same facts of unlawfully taking classified documents after leaving the White House, Would you still have accepted the role of special counsel to investigate former President Barack Obama?
Yes.
Again, considering the same facts, would you have accepted the role of special counsel to investigate former President Joe Biden?
Yes.
Looking back, and you've talked about the investigation steps that you've taken here in the deposition today. I think I've heard you talk about, process of an investigation and how that's important. Would your investigative process have differed if the President of the United States would have been a Democrat?
No.
Someone have a follow-up on that?
Yeah. I served on the January 6th Select Committee, and we spent a lot of time looking through the criminal statutes that may have been implicated in the attack on the peaceful transfer of power, the attempt to overthrow the election, and then the violent assault on the Capitol. And we, in our conclusions, cited a number of statutes which ended up, I think, being part of your investigation, including conspiracy to obstruct a federal proceeding, conspiracy to defraud the United States, false statements, and so on. But you added something which I think was very interesting, which was a conspiracy to violate voting rights, which is something that we hadn't done. And I wonder if you would take a moment to expound on why you thought you had sufficient evidence to prove beyond a reasonable doubt that there was a conspiracy to violate the voting rights of the people.
Sure. The right to vote in a presidential election is one of the most sacred rights that Americans have. And in this particular case, we had strong evidence that the defendants in this case sought to interfere with, obstruct, injure that right. We had evidence, and just a couple examples, where President Trump was asking local officials to find 11,000 votes. When you find 11,000 votes, you're diluting other people's votes. We had evidence that they were targeting certain states, and particularly certain parts of certain states, generally urban parts of states, to have those votes thrown out with no factual basis whatsoever. I believe we cited this in our final report, but there's even statements of the co-conspirators in this case, at least one that's coming to mind now, specifically saying we want to get rid of these votes. We want to subtract them. And diluting the vote count in that way, there's strong precedent for that being a violation of the statute that we charged.
There were 60 federal or state court decisions rejecting claims of electoral fraud, electoral corruption that had been brought by President Trump or his teammates. To what extent did that figure into your analysis of that problem?
Well, the lawsuits, we made clear in our indictment that there are proper ways to dispute an election, and asking for an audit, which President Trump did, and I believe in only 2 of the states that were in question, that's a way you can do that. Filing lawsuits, completely legal and proper way to do that. But in this case, those lawsuits were part of our proof that put President Trump and his co-conspirators on notice. The suits, the results, and the things that court said in finding those suits without merit were one component of evidence that put him on notice that these allegations were false. Also, there were instances where there were protectual lawsuits. There was one lawsuit, for example, that was filed in New Mexico minutes before the deadline, so they could say there was a dispute in New Mexico so they could proceed forward with the fake electors ballot. There was another lawsuit in Georgia where one of the co-conspirators explicitly said in an email, we're on notice that the things in this lawsuit aren't accurate, so we shouldn't have the president sign a certification of this lawsuit. And then they played with the language a little and had him sign a certification nonetheless. And so these lawsuits, well, filing a lawsuit absolutely clearly is something you can do. They were probative evidence of the criminal intent in this case for those limited reasons I just suggested.
Can I go back to volume 2 just for a second? You said that the department gave you access to volume 2 and you chose not to use it?
That's correct.
Did,
I believe so. I did not, given the injunction, want to look at that. And so I believe it was there, but I was looking at other things and I didn't look at that.
Did they give you access to any classified information that was a part of your files?
No.
Did you or your attorneys have any discussions with the department about that?
I don't recall.
Do you still have your security clearance?
No.
When and how was that taken away?
I think in the normal course of things, when you leave government service, you sign papers basically saying you don't have your security clearance anymore. It's vague, but that's my recollection of what happened at my conclusion of my service.
Do you know if your attorneys requested for you to have temporary security clearance so you could review your own files?
I don't believe we did.
And because you didn't look at the volume 2 that they provided to you, you don't know whether or not classified material was provided to you in that volume?
Again, I don't want to speak about anything that could infer the content of volume 2.
When you provided volume 2 to the Attorney General, did you provide proposed redactions?
I believe we did, but I believe we did.
And the redactions were?
But I just want to be, I'm sorry to interrupt you, sir. With the understanding that it was ultimately the Attorney General's decision whether to make it public, whether to do redactions, things of that nature.
And what were the nature of your proposed redactions?
I don't recall as I sit here now.
Was it related to the classified information?
I don't recall. It could have been 6E, it could have been things of that nature.
Did you make proposed redactions because of your concern at all about the ongoing case against Noda and Olivera?
I don't recall that, but I can't be conclusive. I really don't have a good memory of the subject.
Thank you.